SJC-12184, Department of Revenue and others, v. Manuel de Jesus Morales Lopez.
Ms. Luz, good morning.
Good morning, Your Honors. May it please the Court. Jennifer Luz from Goodwin Proctor on behalf of the appellant child. This case, much like the case before, concerns the special immigrant juvenile status designation that the federal immigration law provides. This particular case concerns a little girl who immigrated to the United States when she was 5 years old. Shortly after she arrived here, she petitioned the probate court to enter certain factual findings that would then open the door for her to be able to go to USCIS and request the special immigrant juvenile designation. The probate court made two reversible errors during its consideration of the motion. The first reversible error that the probate court made was that it refused to exercise its authority, its power, and its discretion to make any factual findings, and it did not provide any explanation for its reason to fail to act. The second reversible error comes in the one clue we have from the hearing on why the judge may not have entered any findings. According to the one statement that the judge made during the hearing below, it appears that she refused to enter the factual findings requested based on a misunderstanding and a misinterpretation of the federal statute that says who USCIS may apply this designation to. This little girl is now 8 years old, and she's currently in removal proceedings. She's here before this court today asking this court to reverse the decision below and to enter the findings that were requested. And in fact, Your Honors, I have actually prepared a proposed order, which I'd be pleased to provide to the clerk after the argument.
So are you saying it should go, we should enter the order, or that it should go back?
Yes, Your Honor. We would request in the first instance that this court enter the order. The record below, the evidence below is all submitted in documentary form, and there's a tradition in Massachusetts Appeals Court, particularly in cases like this, that the factual findings can be entered by the appeals court because the factual record and the evidence is the same as the lower court. If this court chooses not to enter the factual findings that are requested, in the alternative, we would ask that the case be reversed, remanded, and that the lower court be given specific instructions to enter the findings requested.
Now, the judge plainly, well, I can't say plainly, but I think pretty plainly, essentially said she's living with the mother, so how am I supposed to, how can I possibly find that it's not viable for her to be reunited with the mother with whom she's living?
That's right, Your Honor.
I think that's ultimately what she did. Now, you're, and you're not claiming that the mother was neglectful.
I am not, Your Honor.
Okay.
That's not our position.
So you're claiming that the father abandoned her.
Absolutely, Your Honor.
Do you think it matters that we don't know the father's name?
We do know the father's name, Your Honor, in this case. But in the other case, no, I don't think it matters that you know the father's name.
Okay. I mean, would it matter if whether, I mean, do we need to say that Mr. Ruiz abandoned her as opposed to the father, whoever he may be, abandoned her?
No, I think, Your Honor, that the test that the SIG statute lays out and the factual findings that are requested by the state court are whether or not a child can be reunified with a parent, and if that reunification is not viable, if that's due to the abandonment, neglect, or abuse or something similar under state law. And to me, Your Honor, if the father is unknown, we don't know his name, we don't know where he is, he has no presence in the child's life, that seems like textbook abandonment, especially under Massachusetts state law. So in that case, I think it would be completely appropriate for the factual finding to be entered.
So what do we do with this statute? What if, are you saying that we as a state Supreme Court should be interpreting that statute ourselves and us trying to understand what Congress meant when it used that language? Or are you saying, no, we should just, immigration, CIS says basically just give us, just do this and let us determine what it means?
Well, Your Honor, that's a good question. I guess what I'm asking you, or what I'm suggesting this court should do, is a little bit of both. I think that the way the statute has been set up by Congress is that it creates a clear role for state courts to use their expertise in child welfare issues and to make these factual findings. But then it also grants the discretion on whether or not to apply that designation to a particular child to the USCIS. And here, what I think is happening, at least in this case for this particular child, and in certain pockets of the lower courts, some of the judges are interpreting the language of the statute about who can get that designation as a basis for not issuing the factual findings on the child welfare issues directly before them. And so to the extent that there is this confusion, or that the judges, like this judge did, misinterpreted the plain language of the statute in order to avoid making factual findings, what that does is it closes the door for this child and other children who are similarly situated.
Is part of the problem that the state statute says may?
I'm sorry, Your Honor?
I believe, does the state statute say may, the judge may find, so that it implies a bit of discretion?
Well, Your Honor, I think even if that were a consideration for the probate court, I think it's clear in this court's jurisprudence in Carter versus Lynn Housing Authority and in other cases that when the judge has a discretion to decide an issue, the judge has to exercise its discretion. And I think that, you know, here, these children, if they don't have a judge rule on the factual request, whether the judge grants it or not, here the judge just refused to make any factual findings whatsoever, and so abdicated her responsibility to actually decide the issue for the child and provided virtually no explanation, which made it difficult to appeal.
Could I ask you the same question I asked the other attorney? Where is the authority for requiring the judge to make these findings?
Well, Your Honor, Congress requests that the state courts do this through the statute, and I think as this court acknowledged in Racinos, Massachusetts state law under Chapter 119, Section 1 provides that the court should provide for and take care of children who have been harmed by parental neglect, abuse, and other similar bases. And here the child was really before the court asking for a factual finding that falls squarely within that. And so to the extent that it's a child welfare issue, I think it's hard to argue that state courts have jurisdiction over findings related to that.
What happens if the probate and family court judge, unlike in these cases, has no affidavit? All that the judge has is a proffer. I don't ask you that as a hypothetical. I sat one day with a probate and family court judge and watched this happen a number of times, and I think it causes a lot of consternation. What's the probate and family court judge supposed to do in that situation when they just have a proffer?
You know, Your Honor, in some ways, I might, if I could, defer that to the amicus counsel, who will be up here representing immigration attorneys who do many more of those and
Sure.
may have seen that. But in this particular case, what I would say is that there was an affidavit that was submitted. It was unopposed. The father was actually in the court that day and didn't oppose the evidence submitted, didn't oppose the entrance of a finding that he had abandoned and neglected his child. He had access to a translator. There was an opportunity at the hearing because both the father was there, the mother was there, and the child was there. And should the judge have been concerned about the adequacy of the evidence before it, had every opportunity to take testimony. But my understanding is that the general practice is that most of these petitions are supported by affidavits, documentary evidence, and that just given the practicalities of probate court, most of the decisions are made on the papers. So Your Honor, I think the first error was that the court refused to issue any findings. And I think the second error here is the misinterpretation of the statute. The language of the statute is plain and unambiguous, and it states that the designation may be applied to a child who is not, the reunification option is not viable with one or both of the parents due to that parent's abandonment, neglect, abuse, or otherwise.
Okay,
And
here's my, I've not gone back to look at the the congressional intent. But there is arguably a battle here between what Congress intended to do versus what Congress arguably may have said. And my question is, do we need to decide that issue and determine that this is what Congress intended, or simply, is there a way in which we can simply say, the Customs and Immigration Service says this is what they want, and just give them the findings that they want?
Your Honor, I think that's exactly right. I think it would be, I think if there's a clear instruction to the lower courts that they need to enter or at least decide the factual issues that are presented to them by the child, it's really a litigation strategy issue for the child, right? If they want to present evidence on one parent, that's fine. If they want to present evidence on two parents, maybe it makes their application to USCIS stronger. I think as long as this court clarifies that the lower courts cannot use an interpretation of one or both to mean both, in order to avoid making the factual findings on the child welfare issues, I think that's probably sufficient. But I think that because we've seen evidence of the lower courts using the language of the statute or reading it in a different way than what the United States has said in its amicus brief here, than what the USCIS policy manual is here, what's happening in effect is that the state courts are making that immigration decision, which really should belong to USCIS. What they're doing is they're saying, I don't think you're going to qualify. So what we're going to do is we're just not going to even bother with the factual analysis. We're not going to worry about it because you're not going to win down the road. And so they are closing the door to these children before they even get to the federal government. They're not giving them an opportunity, and that's what happened here.
So what guidance precisely do you want us to give? Do you want the guidance to be that you make a finding as to both parents, or do you simply make a finding as to the parent who is alleged to be neglectful and abandoned?
Your
And
Honor,
if that's the case, if it's only if they ask for it, what do we do with the last case where it appears that they did not ask for a finding of abandonment as to the father?
well, Your Honor, what you just described is sort of the split, right, between the New Jersey approach and the approach that most other courts that have looked at this. And in New Jersey, what the appellate courts there have said is, you know what, lower courts, you need to decide on both parents and assess the evidence on both parents and make factual findings there. And what New York, California, Illinois, Minnesota, and most of the lower courts here in Massachusetts have said is one, the statute says one or both. All you need is one, and we'll make the findings based on that. I would say, Your Honor, that the New Jersey approach is not the preferred approach. I think it is the wrong approach. I think it's incorrect, because what that does is it places a burden on these children to bring forth evidence regarding both parents. And I think what you have, particularly in this situation, it's a good example of why that's not a good idea. What you have is you have a child whose mother left her alone in Guatemala when she was 3 years old. She was left in the care of her half-brother, who was 10. They were there alone, unsupervised, for 2 years before they came to the United States. It was an incredibly difficult period. They lived in a house with no plumbing, only sporadic electricity, only sporadic access to school. But now they're here in the United States, and this child has been reunified with her mother. She and her half-brother are living with their mother. They're repairing their relationship, and the girl, by all accounts, is thriving. She's in school. She's doing well. She's fluent in English. And you can see, I can see, as I meet with this child over the course of my representation of her over the past 3 years, the bond between the mother and child is getting repaired, and it's getting stronger, and it's getting better. It was broken when they were separated, even though the mother stayed in touch, but now it's getting repaired. And to impose some sort of restriction that would push on that very fragile relationship, I think that's dangerous, and I think it's unnecessary by the statute. I think to put in place a requirement that a child can only get factual findings if they present on both parents, first of all, it's not required by the language of the statute. Second of all, I think it imposes an unnecessary burden on these children. And there are efficiency and policy reasons, such as the ones I just stated, that counsel against it. If the statute says that a child can apply for this designation based on inability to reunify with one or both of the parents, they should be able to present and get factual findings on just one parent.
Okay, and what happens if the child seeks it as to both parents? Can a judge say, well, I find abandonment by the father, therefore I need not reach the issue of the mother? Or is it your view that when there's an allegation of neglect or abandonment, the judge must make findings with regard to each allegation?
I believe the judge should make findings as to each allegation.
So in this situation, if you had alleged that the mother was neglectful, the court should have to make findings as to that, because you would want to take those findings to
think that's right.
USCIS and say, here's as to both. put you in a stronger position.
I think that's right, Your Honor. I think some of the cases have looked at the language of the statute and said, why is it one or both? And they've said, if a child has evidence as to both, then maybe it makes their petition to USCIS a little bit stronger. And if that's what they choose to bring to USCIS to start the process of the SIDGE designation, that's fine. And I don't think that when a child approaches the court in the state and asks for a determination on whether a parent has abandoned or neglected them, that the state should refuse to answer that question.
All right, thank you.
Thank you, Your Honor.
Ms. Badger, good morning.
Morning, Your Honors. May it please the Court, Elizabeth Badger on behalf of AMICI. While the U.S. government agrees with our position on three main points, I'd like to address some of the considerations that underscore why this court does have some role in interpreting the statute and giving guidance to the lower courts to address some of the concerns that Justice Gantz recently presented. I can also turn attention to your earlier question, Justice Gantz, regarding neglect in the face of poverty, as well as Justice Lowy's question about the scenario where there might be an absence of an affidavit. First, the three main points in which we agree with the government are as follows: that reunification means a stable long-term living arrangement. Second, that the plain meaning of one or both is that a court need find reunification is not viable with only one parent to satisfy the SIJ statute. And third, that the state court should not be evaluating discretionary merit or the child's motives in seeking the child welfare determinations. That's an issue left for the agency. So as my sister was referring to earlier, if you take the government's position as being that the state court should simply evaluate the request that's presented to it, or evaluate whether reunification is not viable with the defendant parent, then we agree with the government. But if there's any implication in the government's brief, in the footnote where it juxtaposes the HSP, the New Jersey case, with the cases interpreting the statute, that this court should follow the New Jersey approach in requiring that a court make findings against each parent, we would part ways with the government for 4 reasons. The first is the plain language of the statute. And since the enactment of the TVPRA, the statute has been applied in that way, that only a finding against one parent is required. And the vast majority of our state court judges have applied it in that way as well. Secondly, as counsel, we can't bring a frivolous case against a parent where there's been no mistreatment or underinvestment by that parent. On the flip side, we don't want to take up the state court's resources in proving a negative or requiring additional procedures that are unnecessary. And lastly, as my sister also referenced, these families are delicate. Going into court is intimidating. We don't want to bring a good parent, put a good parent on trial for the sake of making a finding that's unnecessary. So if a request for findings against both parents is presented, that request can be evaluated, but the state court should not go further and require additional procedures or parties that are unnecessary to what is an undisputed application of the statute. To Justice Lowy's point earlier about the scenario where there is no affidavit, my sister is correct. The vast majority of cases, I think I can say, representing cases represented by kind and by the legal services that AMICI consist of, it is by and large the practice that we submit detailed affidavits and other evidence to the court. I think at least the handful of cases that have been addressed by the appeals court below, as well as the Racinos case, had a substantial affidavit describing the abuse, abandonment, neglect, and the other points that the child must establish to be eligible for the findings. As to the question about neglect in the face of poverty, because I do think that's an important point, I don't think the court needs to make any kind of blanket determination about neglect in the face of poverty. The question is always going to be, case by case, how the parent responds to the situation, and every case presents different factors. In the Pinati case, for example, the mother reacted to the poverty by forcing the child to leave and sent her into a dangerous neighborhood every day, and putting really the parenting role on the child. The fact that mom made her leave and she ended up living with her uncle, and that was an ultimate benefit to her, living with her uncle in the United States, doesn't negate what happened while the child was living with her mother. And what happened while she was living with her mother is evidence of the conditions, the neglect that she would return to. So I think in every case, in spite of poverty, we have to look at how the parent has reacted to that situation.
Now, if we were to say CIS wants us to do this, and we will do what CIS asks us to do, what happens if on January 21st, CIS says something differently?
Your Honor, I think that Congress would have to change the statute for CIS to change its interpretation. The congressional intent is evidenced by the plain language and the change of language that happened from prior to 2008 to the 2008 amendments. And if there were statutory change, it would be up to council to accommodate and present a different request to be evaluated by the state court.
So you're saying we should reach and make our own independent determination of congressional intent and what the language truly means, and not simply say we rely upon CIS?
I think the congressional intent in the change in language is persuasive, is an assurance that when council presents findings, or when the child presents a request for findings to the state court that only address the non-viability of reunification with one parent, that is sufficient, that is fine to let the state court make that determination, not reach an unnecessary issue of the non-viability of reunification with the other parent, and let the agency then evaluate the sufficiency of those findings.
All right, thank you.
Thank you, Your Honor.